The next matter to come before the court this morning is State of Ohio versus Kittle.
Take your shots.
Both sides will have 15 minutes to present oral argument this morning. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time, you let me know when you get started. I'm keeping the clock and let you know how time is passing through the argument. The court has read the briefs. We're ready to see when you are.
May it please the court, my name is Rebecca Black, and I am here on behalf of Dana Kittle, who is the defendant appellate in this matter. I'd like to reserve 5 minutes for rebuttal. Of the 3 issues that I presented to the court on her behalf, I'd like to focus my remarks on the first assignment of error, which actually has 2 parts to it. It has to do with whether the NPLEX records, that's the National Precursor Log Exchange records, that measure the amount of, pseudoephedrine, also known as Sudafed, bought, whether those records are testimonial or, assuming they are non-testimonial, as the prosecution would have it, whether the police officer that presented those records and spoke about the foundational testimony about those records was a qualified witness under 803-6 to do so, to establish the authenticity of the records. The records are in fact testimonial. There is a great abundance of case law that talks about other types of records that are business records that are not testimonial, including one of the main cases of my brief, State v. Hood, which is the Ohio Supreme Court case from about 2010, 2012, I believe, that discusses the matter as it pertains to cell phone records. But as this issue of testimonial versus non-testimonial for confrontation clause purposes presents itself in this case, NPLEX records are unique. They are a business record, but part of our question is not only whose business record are they, in what general course of business are they kept and managed and things like that, so that we know who a qualified witness or a custodian of the records may be, but also for what purpose those records are collected. Now, some of the cases in both sets of briefs, State v. Coleman, as well as it's a 5th District case mentioned in both briefs, as well as the testimony of the police officer, Lemanier, both talked about the idea that this set of records, these NPLEX records, are kept for the purposes of methamphetamine lab cooking assembly of ingredients for interdiction. The idea that this isn't just an autopsy record that has to be conducted as a matter of law, and it may or may not be something that's used in later evidence. NPLEX records exist for the purpose of methamphetamine labs and prosecuting them. And the other point I'd like to make about the authenticity of these records, that is a foundational requirement, as you are aware, under the hearsay rules, such that we have to know that the record being offered into evidence is being offered, is what it purports to be. And when it's offered by a cop, by someone like Officer Lemanier, as it was in this case, that cop is only looking at the output of a document, of a system that is managed by a third-party company known as APRIS, A-P-P-R-I-S-S, which is also mentioned in my brief, as well as the pharmacy who inputs information into this document, this system. The other cases that were mentioned in the prosecution's brief all had someone other than just simply the cop who looks at the output, who only has access to that information. But the people who had knowledge of how the information got in, including the pharmacist, including these representatives from APRIS, have been used in other cases to establish that authenticity of the records pursuant to 901B10, which is what is required under 8036. The standard of review in this case is in fact de novo because of how well preserved the error was below. Trial counsel made a specific point of objecting on the record pursuant to confrontation clause and the corresponding segments of the Ohio Constitution. And for that reason, this is not a harmlessness standard of review that must be, it's not an issue of the harmlessness of this error.
Would you equate the report to a lab test done by BCI as far as the testimonial nature of the document? When the BCI does a lab test, it's clearly used for trial purposes against a defendant. This seems to be a different type of report. How would you respond to that?
I think that is a good analogy because the lab report, we don't have a cop come up and talk about the lab report. We have the person who ran the tests, who compiled the report, come before the trial court to testify about what the findings were. That person has knowledge of what is in the document, was the person who created it, they are a true custodian of that record. But as I think about it, on the other hand, those records for a BCI report are not business records, which is really what this is a business record generated in the course of regular business of APRIS.
Would
Not
it be comparable to the BNB? Driver's license, driver's records from the Ohio Department of Vehicles, and then like the police pull up on a needs report?
that would be a self-authenticating record, and I don't believe that this would be the case. There's so much room for human error. It's not a single input that we're looking at here. It's multiple inputs of identity information, not just purchase information. I guess the primary issue of whether or not a police officer can be a qualified witness is what their knowledge is of the system, how it works, why something popped up on the screen that they see. In this case, Officer Manier was talking about, well, I think this is what I think is the reason, and it may not be the word think that he used, it was something of that tenor though. The idea that he wasn't sure exactly why there was this mismatch of information on the expanded exhibit provided, the 36A, that you should all have in the record, versus regular prosecutor's 36 exhibit. And without that knowledge, in a concrete way, nobody knows why there is this difference between the two documents. And that does, in fact, lead into the second assignment of error, having to do with the trial court abdicating his duties as a fair and impartial arbiter by ordering an expanded document to be produced. This expanded document provided new information to the finder of fact, to the trial court, and it's not just beneficial to the prosecution, it just goes beyond that as far as entering new facts into the case that were not previously disclosed to the defendant and to her counsel at trial.
Now, what concerns me about that is the council was offered an opportunity to have the case continued or delayed, I can't recall. which
Continued
was-
to put it on hold for, I think, a day
that
or
was
two.
fatal, the fact that they turned down that opportunity.
I think that goes to how severe the harm done was. This was, the entire trial strategy was based on this one point. If something the judge has asked to bring forward as a finder of fact, not just as a judge who can, in a jury trial, ask questions of a witness, but this further evidence was produced at his command. That's really what the problem becomes.
And you're just now reaching into that 5 minutes of rebuttal, you can proceed to reserve as you wish.
In conclusion, Your Honors, I would just summarize by saying that this case should be reversed and sent to the trial court for further proceedings. Thank you.
May it please the court, my name is Richard Casey. I'm representing the state of Ohio in this case, and I will likewise welcome Judge Teodosio to the bench.
Thank you.
I will start with the last portion of counsel's argument. That would be Exhibit 36 and 36A. The major difference you will see when you look at these things is 36A has Dana Kittle's signatures on it when she purchased the Sudafed or the pseudoephedrine product. Now what happened apparently is that 36A is the latest report, the NPLEX report that was available to the officer on the day when the case came to trial, and the officer had not run it and had instead given the prosecutor Exhibit 36. Somehow it was discovered that there was a later report, and at that point Judge McKinney told the officer, well, go run the thing. And Judge McKinney made some findings. He said that the defense was surprised, should have been produced, not the fault of the state. The officer just, for whatever reason, didn't do it. There couldn't have been any sinister motive in the officer not running the latest report because the report was not exculpatory in any manner. Something the cop should have done but didn't. So Judge McKinney gets a hold of the thing, 36A, gives it to defense counsel, and says, here it is. I'll give you time to digest, reformulate your trial strategy if that's what you want to do. You tell me what you want to do. Again, with the foundational findings that while it could technically be called a discovery violation, it was not willful, and again, it was not exculpatory information. At that point, defense counsel says, no, forget it. I'm going to go with what I got, which was 36, and refuse the court's offer. So, to say that Judge McKinney was somehow biased or prejudiced toward the state, I think is a bit of a stretch. When the judge became aware of the latest information, he required it to be produced. I don't know that at that point he knew what exactly was in it. So, for all he knew at that point, who knew what would be in there? I think the bottom line there is, trial courts under the rule are supposed to be guided by the ascertainment of truth, and that's all Judge McKinney was doing here. When he knew there was new evidence, he required the state to produce it. He gave it to the defendant, and the defendant had full reign to do with it what the defendant wished to do, including arresting the trial for a bit to give the defendant time to digest that information and use it. So I think there's nothing to that assignment of error. Now getting on to NPLEX. BCI reports, well, they can be DNA, blood, operability of a firearm, fingerprints maybe, if BCI is even doing that anymore, comparing tire treads, footprints, whatever. But what's different in that situation or situations than what you're dealing with here with this NPLEX statute and report, BCI does that DNA report when the state of Ohio has indicted Rick Cassay for some offense and there's DNA involved. So, is it my DNA or what's the frequency of occurrence? Is it a lot or is it a little? So we have a named defendant and a report generated for the specific purpose of prosecuting that named defendant. Now what NPLEX is, in Revised Code 37-1505 sets it out. The guts of that statute, as far as the state is concerned, is there is a limit set on what a person can buy concerning pseudoephedrine products, be they Sudafed or however that drug may be packaged. 3 6/10 gram within a single day, 9 grams within a period of 30 consecutive days. By law, that is all that an individual in the state of Ohio is allowed to purchase. Why? Sure. Because even though the drug du jour appears to be heroin, we still have a massive amount of methamphetamine being used in manufacture. It's still a big problem. So what the statute does is set that limit, and then it sets a reporting system, which the officer in this case described in detail, and the statute sets out in detail, to be sure that a person cannot violate that limit. When you or I go to a pharmacy, I want to buy full-strength Sudafed. Here's my driver's license, they scan it, I have to sign a logbook. That is entered into the database. Sure, that is available to the police. This officer had some kind of gizmo on his desk where he would get an alert when Rick Cassay goes into Acme and buys a pack of Sudafed because he has a bad cold. He knows that. But it's not like a BCI report. That NPLEX data gathering system is not there to prosecute me or any other individual. And it is not there for the primary purpose of providing evidence in a criminal trial. It's there, what's the word? It's made to show compliance with the rule. The rule is this amount you can have, this amount you can't. The NPLEX data gathering system is a system designed to show compliance or non-compliance with that fundamental premise that you can have this much but not this much.
Mr. Cassay?
Yes.
If a person were to go in and try to purchase more than they're allowed to have, would something come up and say, no, you can't sell any more to this person?
What the pharmacist is supposed to do is not sell it.
And they would know that by looking at the
Yes,
report?
I think that would show up as what they call a denied purchase. I believe that's the terminology that they use. But you can't do it, unless the pharmacist is asleep or not doing what they're supposed to be doing.
Is law enforcement automatically contacted then?
This officer is. Lemonnier, if I'm pronouncing that right, he uses NPLEX every day. So he is tasked with that particular branch of law enforcement to look out for over the limit or multiple purchases as part of his job. So he in particular, Your Honor, uses this every day. Again, he has some kind of machine or warning device, according to him, that's on his desk. And when anybody purchases pseudoephedrine product, he knows about it. So, now not every cop obviously has that ability or capability. He does. When you talk about a business record, you're talking about two things. You're talking about some regularly conducted activity. NPLEX is regularly conducted because the law says it has to be regularly conducted. Every pharmacy that sells pseudoephedrine products has to do this reporting, or has to play into or be connected to this reporting system. The law requires it. So it has to be regularly conducted in the business of selling drugs. Then you have an authentication requirement. Sure, in this case, if we have brought in the pharmacists on each particular day, or as it turned out, the primary date at issue was November 30th of 2014. So if we brought in Mr. Pharmacist from App.No or wherever and said, yeah, that's the record that I generated when Dana Kittle bought Sudafed, no doubt, that's proper authentication. The issue here is we didn't have the pharmacist, we had the officer Lemonnier. So we have to look at what type or what is the degree of authentication that's acceptable for Judge McKinney to admit it in the exercise of his discretion. This is discretion, it is not de novo. This court has held authentication is subject to the abuse of discretion standard. So, what's the threshold? First-hand knowledge, and I'm quoting from McDonald, case I cite, first-hand knowledge of the transaction is not required. This is paragraph 28. What has to be there is your authenticating witness has to demonstrate sufficient first-hand knowledge so the finder of fact can believe that it is what the proponent, here the state, is what it says it is. He can reasonably testify on the basis of his sufficient familiarity that the record is what it purports to be and that it was made in the ordinary course of business, consistent with 8036. Now this officer, probably unlike most cops running the street, can do that. He uses it every day. He has testified before, I cited the case, I think it's State versus Kirby, where this court cited him in holding that the evidence in that particular case was not against the manifest weight of the evidence. So he's no stranger to the courtroom.
I think that was a sufficiency case.
Sufficiency, okay, I stand to be corrected.
That's okay, it's just that, if it was improperly allowed, of course, under sufficiency, we're not gonna look at that, so but yes, you are correct, he was just cited as an individual who testified about it.
So my point is he obviously has some familiarity with NPLEX, and he testified, like I say, he uses it every day. He knows what it is, he knows what the pharmacist does or is supposed to do, he knows what kind of report is generated, he can run the report at will, he has his own password, secure password, he is logged into the system, he can generate the reports. So does he have sufficient first-hand familiarity with what NPLEX is and what kind of report it generates? Judge McKinney said he did, and the state of Ohio is submitting to this court that Judge McKinney did not only abuse his discretion, did not abuse his discretion, he's correct. This cop is an expert.
Does it make any difference in this case if the officer can generate the written exhibit himself as opposed to go to the pharmacy and say, please give me this business record exhibit? Does it make any difference if the officer himself can generate the hard copy of what he can already see on his computer?
Well, Your Honor, I think at a minimum, it would demonstrate sufficient confidence in that officer by the law enforcement agency that they are going to entrust him with that ability. This is like, running a no labor report. Not everybody can do that. It's cabined so that only certain people in law enforcement have access to it. This officer has that ability to run it at will. I think rather than being irrelevant to his qualifications, it bolsters his qualifications because he's recognized by his department as somebody who is so familiar that he can run the report when he needs it. He does not have to go and get it from the pharmacist. Please do this for me and tell me what all these numbers mean. He knows what they mean. I believe my time is up, but maybe not.
I just have a quick question. How do you square this with, I'm looking at United States versus Collins, which I think State versus Isaac cited, that an APRIS Inc. employee was a qualified witness. That would be the person whose software runs the program would be a qualified witness.
Well, that would be a super qualified witness. Just like a pharmacist would be better in the ordinary case than Officer Lemonnier, but we're not looking for perfection. We're looking for somebody who has sufficient familiarity, who can meet that threshold where the finder of fact can say with some degree of confidence, this is what the proponent says it is. So sure, we could bring in the person who sets this up, this whole computerized database up. That would be cumbersome, but it would be overkill in the ordinary case. Now, we can probably imagine a situation where some defendant mounts a full-throated attack on the NPLEX system and says the computer wires aren't set up right, and we don't have sufficient memory or some complex challenge to the system that is not made here, then maybe somebody like that we'd have to get. But for this, the state believes that Officer Lemonnier was enough of a witness to authenticate the business record, and the court properly admitted it.
Thank you.
Thank you.
Counsel, you have just under 5 minutes remaining for vote.
Can you pick up where he left off? What part of the record you were referencing? I think identification issues where the officer was confused or not clear.
Correct. One of the biggest things, he's looking at it, he doesn't even know the name of it. It's the National Precursor Log Exchange. He calls it something to the effect of the National Law Enforcement Exchange, which also goes to that issue of, yes, this is a testimonial document. And he only knows what he sees on the screen. He doesn't know for sure, with personal knowledge, to any reliable degree of certainty, why it got there. He's hypothesizing about, well, back before it got electronic and it was just in the books, maybe that's why there's all these other addresses from, I think it was like Alaska, that were coming up under the name Dana Kittle. And we have all this mismatched information on the expanded Exhibit 36A. For him to not be able to answer those questions with personal knowledge and personal understanding really speaks to the fact that he is not a qualified witness. He doesn't know why the record is what it purports to be. He just knows he goes to a computer and can print it off. And he also doesn't know what it is, or at least doesn't state on the record, why he is licensed, or what exactly it was he had to do to be licensed in order to have that password into the NPLEX system. He just knows, oh, I applied, I gave him my name, and look, and now I have his password, is essentially what he says in about 3 lines of the transcript. Additionally to that, when we're looking at the standard of review, I believe Mr. Cassay had mentioned that the authentication requirements should be reviewed abuse of discretion. I submit that this is different because this is viewed within the lens of the confrontation clause analysis. It's not just authentication as it relates to hearsay. This is authentication as it relates to a confrontation clause violation.
Are you suggesting then that anytime somebody goes into a pharmacy to purchase food, that they might go to Walgreens, to Rite Aid, to CVS, to Walmart, any place they go, you'd have to bring in a pharmacist from each one of those places to authenticate each entry into the NPLEX system?
If each of those entries is important to the state's case, then yes. They have personal knowledge of what goes in it. They're the ones entering in the information into the database that APRIS keeps. And that was found, the combination of pharmacists and police officer was found to be sufficient in the Coleman case, as well as I think I believe it's called McDonald case out of the 5th District. And you're right about the Isaac case, they had just an APRIS employee, and that was very recent. I can supplement if you'd like. And as to the 3715.05, it's not just a limit establishing how much a person can buy. It establishes that section of code with the corresponding ones that follow. It doesn't just track a limit, it tracks all purchases and denials. You know, it's not just a matter of what it does, it's also why it does it. It's not just keeping track of this for the sake of monitoring the economy in this particular medication. It's the compliance with the rule is for the purpose of decreasing the methamphetamine epidemic. The other issue I wanted to address was this 36A. We're not talking about more recent in time information. We're talking about information that existed all along. It was contained within the document, the overall screen. He could have printed it off at the very beginning. This isn't an update per se. This is more in depth of what was already there. Yes, there were, I think, maybe a few new purchases or something. I may not be right about that. You'd have to compare the exhibits. I think it's mentioned in my brief, but.
And counsel, regretfully, I need to inform you, you have utilized your 15 minutes of time for oral argument this morning. Thank you so much.
Thank you for your time, Your Honors.
Thank you both for your presentations today.